The matter is for ruling.
Yes, my lord.
Yes, my lord.
All right.
Okay, we are ready.
Okay, the court is ready as well.
As the court places.
So I shall proceed accordingly with the ruling.
As the court
As the
places.
court.
The first and second respondents applicant hearing via the motion dated and filed on 24th October 2025 and brought pursuant to the Fundamental Rights, Human Rights Enforcement Procedure Rules 2009 and the rules of this court, particularly Order 25, Police Section 36, Constitution, Federal Republic of Nigeria, and under inherent jurisdiction of this court. 6. The following orders. Order for extension of time within which the respondents, first and second, may file respondent joint counter affidavit in opposition to originating motion in the suit out of time, the time for filing same having elapsed. 2. Order deeming the first and second respondent joint counter affidavit already filed and served as properly filed and served, the filing fees having been paid as a separate process. And 3, for such further orders as court may deem fit to make in the circumstance. The application is founded upon 5 grounds as contained on the face of the motion paper, and supporting the application, stamped paragraph affidavit deposed to by one Mohammed Bala Yushau, a litigation secretary in the firm of counsel representing applicants, as well as written address in support of the application. In the written address, learned counsel to the first and second applicants, defendant applicants, formulated a sole issue for determination to wit, whether in view of the affidavit evidence in support of the motion or notice, this honorable court can exercise its discretion to extend time for the respondent applicants to file first and second respondent joint counter affidavit in opposition to originating motion out of time to do so having elapsed. Relying on Order 25 Rule 4 of the rules of this court, counsel here submitted that the court is empowered to grant the application, and in view of the facts contained in the affidavit, he argued that the essence of extending time for applicants is to enable them to be heard properly in the matter, and that this accords with the principle of fair hearing. This is stated is in addition to the fact that it will not occasion any injustice to the opposing party. Citing Obeta versus Sokwe, citation is provided to buttress his position and finally urge the court to grant his prayer. In reaction, that is, upon receipt of the instant application, the claimant respondents filed counter affidavit on the 3rd day of November 2025, deposed to by the claimant himself with a written address also. And a sole issue has been raised for determination whether first and second respondent applicants have placed before this court any cogent, credible, or exceptional reason to warrant the grant of the application for extension of time. The crux of the respondent's argument here is that the grant of an application for extension of time is hinged on the presence of good and cogent reasons on which the court will exercise its discretion. He cited in support the case of Chime and Ude, among others, while contending that the applicant's hearing have not placed such cogent material evidence before the court to appeal to the exercise of its discretion in favor of the application. He maintained that merely stating in the affidavit that counsel handling the matter was hospitalized without more is not sufficient. It's not sufficient. This, he stated, is in addition to the fact that the law firm in question has other junior counsel. Furthermore, respondents' counsel posited that cases of fundamental human rights are time sensitive and need be dealt with expeditiously, relying on Order 2, Rule 6 of the Fundamental Human Rights Enforcement Procedure Rules. In all, he urged the court to refuse the application. Now, the first and second defendants, applicants filed a further affidavit of 17 paragraphs in support of the instant application, which was filed 17 November 2025 and deposed by the same Bala Mohammed Yushau with the written address filed alongside, wherein counsel raised the sole issue for determination to wit, whether in the prevailing circumstances of this case, applicants have made out a case or the grant of an extension of time in the overall interest of justice. Relying on Order 25 Rule 4 of the rules of this court, counsel here submitted that the court is empowered to grant the application, and in view of the facts contained in the affidavit, he argued that the essence of extending time for applicants is to enable them to be heard properly in the matter, and that this accords with the principle of fair hearing. This is stated is in addition to the fact that it will not occasion any injustice to the opposing party. Citing Obeta versus Sokwe, citation is provided to buttress his position and finally urge the court to grant his prayer. In reaction, that is, upon receipt of the instant application, the claimant respondents filed counter affidavit on the 3rd day of November 2025, deposed to by the claimant himself with a written address also. And a sole issue has been raised for determination to wit, whether in the prevailing circumstances of this case, applicants have made out a case He argued that the discretion of the court to extend time is a judicial one and not one meant to be used as a punitive measure, in addition to the consideration of doing justice. Counsel submitted that the respondent's counsel's argument against the grant of the application is suggestive of infallibility, which is alien to litigation practice. He maintained that ill health, as opposed to, is a reasonable excuse to be considered in the grant of this application. More so, as the National Industrial Court of Nigeria in Order 1 Rule 2, Sub Rule 2 of its rules has been mandated to eschew technicalities so as to focus on the merits of a case. Also, that the argument by respondents counsel to the effect that first and second applicants filing of notice of preliminary objection. Counsel, please, you are before the court. I will take that again. Also, that the argument by respondents counsel to the effect that first and second applicants filing of notice of preliminary objection and counter affidavit is an abuse of court process is legally untenable because, in his opinion, it is a prudent approach to ensure all grounds are covered. In conclusion, he urged the court to grant the application. Equally, the 3rd to 7 respondents filed the application. That's now 3rd to 7 respondents applicants motion equally for extension of time. They filed the motion filed on 24th October 2025 with materially the same prayers as that of the first and second defendants, with the counter affidavit and written address filed alongside. Similarly, in response to the above motion, applicant to respondent filed a similar counter affidavit and written address, just like the one in response to first and second defendants' processes. Thereafter, 3rd to 7 respondent applicants filed on same 3rd November 2025 their further affidavits in support of the motion with the written address as well, which equally is materially the same as that of the first and second respondent applicants. Relevant facts and submissions therein are all duly noted and will be referred to in the body of the decision as the need may arise. Having considered the processes filed, now the decision of the court. Having considered the processes filed by the parties and the arguments canvassed for and against the grant of these motions for extension of time, it is pertinent to state that it is Order 57 Rule 4 of the rules of this court, which empowers this court to make orders extending time for the doing of any act as required, and not Order 25 Rule 4, as cited by the respective applicants' counsel. The main purpose of the above provision is to ensure that the party is heard on the merits of his case and not to be unnecessarily shut out. In consideration of the submissions made by respondents' counsel with regard to the exercise of discretion of this court, I align myself with his position that such discretion, when exercised, should be done judicially and judiciously with a view to doing substantial justice. Respondents' counsel had argued that the mere deposition on behalf of the first and second applicants that counsel handling the matter was sick and hospitalized without more is not sufficient reason for the court to exercise its discretion in favor of the grant of this application. I have perused and considered the affidavits in support of the two similar applications and their further affidavits, which, aside from stating facts of ill health of substantive counsel handling the case, that is for first and second applicants, as the reason for their delay, they did not furnish the court with any medical reports or other evidence to establish their assertion, while 37 applicants on their part only stated that their being out of time was not a deliberate act. The foregoing, I must say, is not good enough material before the court, and I so hold. Be that as it may, have observed that the originating motion in this suit, as alluded to by the respondents, was served on the applicants on 3rd day of October 2025, even though filed on 13th August 2025, and that by the Fundamental Rights Enforcement Procedure rules, they had 5 days to respond to same, which time elapsed on 8th October 2025. Thus, by 24th October 2025, when they filed their processes, they were out of time by 16 days. It is, however, on record that the said applicants have filed the required processes with these motions that seek to regularize them and have paid default fees also. I'm minded to state that even though not much cogent reason was furnished to the court for the grant of these applications, I do not see the injustice that will be occasioned against the respondents in the grant of this application. This in addition, this is in addition to the fact that it will aid the court to determine the matter on the merits, and by that, doing substantial justice to all parties. In the end, and in view of all I have said above, I hereby exercise my discretion granting the two motions for extension of time in the following manner. A. Order is made extending time within which the first and second respondent applicants may file respondents' joint counter affidavits in opposition to the originating motion in this suit out of time, the time for filing same having elapsed. B. An order is made deeming the first and second respondents' joint counter affidavits in opposition to the originating motion already filed and served as properly filed and served, the filing fees having been paid as a separate process. C. An order is made extending time within which the third to seven respondent applicants may file their respondents' joint counter affidavits in opposition to the originating motion in this suit out of time, the time for filing same having elapsed. And four, an order is made deeming the third to seven respondents' joint counter affidavits in opposition to the originating motion already filed and served as properly filed and served, the filing fees having been paid as a separate process. Ruling is hereby entered.
Haastrup, please.
As court places.
As the
So, I think we have a preliminary objection aside the originating motion. So we'll
Yes, my
take
lord.
a
Yes, ma'am.
date. We'll take both together and we give you a date for hearing, for definite hearing.
As the court places.
as the court, please.
What dates do we have for Sokoto again? Fourth. Okay. Council, you may check your respective diaries. 4th day of March, please.
4th. It's
Yes,
convenient,
go
my lord. It's convenient.
All right. Yes. How about the
Okay.
other council? Are we all in agreement as to that date?
4th of March, my lord, is convenient.
Yes. All right.
Convenient, my lord.
So case is further adjourned to 4th day of March 2026 for definite hearing of the preliminary objection. It shall be taken alongside the originating motion.
As the
As
court
the court,
places.
please.
All right.
We are really
I'm most
grateful,
grateful,
and
my
I
lord.
sincerely apologize for my interruption while delivering the ruling.
That's all right, counsel. Thank you.
Thank you, my lord.
What's the next on the first list for Sokoto? Do we see we have yes, there's another ruling. Then, yes, before that, I think we stand down and I take the ruling for Abuja. Abbas,
My lord,
yes, we'll stand down the number 5 on Sokoto list. We'll stand
Haastrup, please.
down for 15 minutes. So we have a ruling for Abuja, and we'll quickly take that of Abuja and get back to you again.
Haastrup, please, my lord.
So inform council, we'll stand down for just 15 minutes.
Haastrup, please, my lord.
All right, okay. Let's stop. Abbas, are you connected? Sokoto?
My lord, we are connected.
All right, thank you.
Thank you, my lord.
So let's go ahead with the next matter for Sokoto.
Escort, please, ma'am.
Yes.
NICN/SK/05/2025 between Professor Ibrahim Garba and two others, versus Governing Council, Federal University Gusau, and four others. My
Yes.
lord, the case is ruling.
Parties are absent.
Parties absent, my lord.
Thank you. Legal representation, please. Appearance, any counsel? Okay. I have in Abuja here. Bello Umar.
And Ibrahim Ali.
Ibrahim Ali.
Yes, my lord, and Mubashar Umar.
Sorry, are you appearing with another counsel?
Yes, my lord. It's Mubashar Umar.
Okay, with Mubashar Umar.
Yes, my lord.
Yes. You are for?
It's for ruling. For the defendants.
I know it's for ruling. Which party are you representing?
Defendants, respondents.
All right, thank you.
Thank you, my lord.
I shall proceed with the ruling.
The court pleases.
Claimant applicant's motion on notice is dated 15 September 2025 and filed 19 September 2025, pursuant to Order 17 Rules 1, 4, 22 Rules 1 and 2 of the Rules of this Court, and under inherent jurisdiction of courts. Applicants are by the application praying the court for the following orders. An order of interim injunction restraining the defendant, respondents, their agents, etc., acting on their instructions from implementing, enforcing, or proceeding with the Vice Chancellor's selection process based on the advertisement dated 25th August 2025, which is Exhibit B, published in the Daily Trust newspaper, which imposes a 10-year post-professorial experience criterion purportedly derived from the unlawful council meeting of 21st to 25th July 2025, which is Exhibit H, for lacking legal basis and or reliance on a non-existent regulation pending the determination of the substantive suit. 2. An order of interim injunction restraining the defendant, respondents, their agents, etc., acting on their instructions from taking any further steps in the Vice Chancellor's selection process based on the said advertisement, Exhibit B, including but not limited to receiving applications, shortlisting candidates, or conducting interviews pending the determination of the substantive suit. 3. An order directing the defendant respondents to preserve the status quo ante bellum as prior to of 25th August 2025, the publication of the impugned advertisement Exhibit B, pending the determination of the substantive suit. 4. An order for accelerated hearing of the motion on notice and the substantive suit to prevent prolonged uncertainty in the university's governance. The claimant applicant undertakes to pay damages if this order is found to have been wrongly granted. This application is accompanied by 16-paragraph affidavit deposed to by the second claimant applicant, Professor Ahmad Galadima, with exhibits B, C, D1 to D2, F, G1 to G3, H, I, J, and K, and next, and a written address dated 15 September 2025 in support of the application. Learned counsel for the claimant applicant has in the said written address formulated the loan issue for determination thus: whether in view of the facts and circumstances involved, it is in the interest of justice to grant this application. Counsel referred the court to Kotoye and others versus CBN Obeya Memorial Hospital versus AG Federation, 7-Up Bottling Company Limited versus Abiola and Sons Limited. All citations provided. Vis-a-vis the affidavit in support of the application to the effect that the application is deserving of the exercise of this court's discretion, having satisfied the requirement for its grant. More so that the idea of granting this application is to maintain a responsible position among the parties pending the determination of the substantive suit, urging the court to so hold. Relying amongst others on United PLC versus IC, counsel further submitted that the idea of granting an order of injunction is generally to protect an existent legal right with the object of keeping matters in status quo until the question in issue between the parties is determined. Citing Salami versus Yahaya, he then referred the court to the following principles as enunciated by the court in Uked versus Okwa. 1. Balance of convenience of the parties before the court, maintenance of status quo ante bellum, the relative strength of the case of the parties before the court, conduct of the parties, and lastly, inadequacy of payment of damages, which are to be considered in determining an application of this nature. According to applicants' counsel, the balance of convenience is on the claimant applicants, as they will suffer more convenience if the application is not granted, having the legal right to participate in the lawful selection of the Vice Chancellor of the Federal University, Gusau, by virtue of their employment and promotion letters. They have also held different positions in the university, including the Deputy Vice Chancellor. Thus, applicants will suffer more inconveniences as they will be deprived of doing a lawful duty. In aid of his argument on this point, learned counsel relied on the case of ACB versus Awubolo. He then submitted that where status quo ante bellum is not maintained in this matter, there will be an irreparable damage against the applicants. Hence, that the applicants have a right to protect and seeking a remedy before this court to protect him. Counsel continued that where an application for injunctive relief seeks a discretionary remedy, such discretion must be exercised judicially and judiciously in order to preserve the status quo ante bellum and forestall irreparable injury to the applicant's legal or equitable rights. He then relied on the case of Madubuke and Madubuke. He further relied on Order 17, Rule 8 of the rules of this court and submitted that it is in the interest of justice to grant the application, particularly because allowing the respondents to go on with the Vice Chancellor's selection process as scheduled will prejudice the applicants. He then urged court to so hold and resolve the sole issue in favor of the applicants. Now the counter affidavit of defendant respondents. This was filed on 8th day of January 2026 and is of 31 paragraphs, deposed to by one Abdurrahman Adamu, an employee of second defendant respondent, a senior lecturer in the Department of Political Science of the second defendant respondent. And next to the counter affidavit are exhibits B, C1 to C2, D, and E1 to E4. The said counter affidavit was filed alongside the written address, which were all filed via the motion of notice, dated and filed 8th day of January 2026, and deemed properly filed and served by order of court granted on 22nd January 2026. In his written address accompanying the counter affidavit, learned counsel for defendant respondents formulated the sole issue for determination, thus, whether the applicants are entitled to an order of interim injunction against the respondents based on their averments in the supporting affidavit, counter affidavit, and the extant provisions of sections 2AA, 2AAA, and 3 sub 2 of University Miscellaneous Provisions Act 2013 as amended, and sections 3 sub 1 and 6 sub 1 of the Federal University Gusau Establishment Act 2019. It is submission of defendant respondents counsel that the grant of an injunctive order is at the discretion of the court. It must be exercised judicially and judiciously based on the facts made available to the court by considering at first whether sufficient materials are placed before the Honorable Court, explaining through the affidavit evidence the reason why the court should exercise its discretion in favor of the applicant, that in the instant case of alleged breach of the provisions of the Universities Miscellaneous Provisions Act, it is the mandatory duty of court to consider the act complained of alongside the provisions of the law alleged to have been breached. Counsel submitted that the defendant respondents had complied with the provisions of section 2AA, 2AAA, 32, of the Universities Miscellaneous Provision Act as amended, and sections 3 sub 1, 6 sub 1 of the Federal University Gusau Establishment Act 2019, and advertised for vacancy in the office of the Vice Chancellor, Federal University Gusau, which is Exhibit B, that the advertisement was open to the public who may be qualified to apply, but the applicants chose not to apply for reasons best known to them. To counsel, there is no law cited by the applicants which binds them to adopt or comply with the precedent in other universities, which probably allows persons with less than 10 years experience to apply for the position. Counsel continued that the respondents hearing have cited the provisions of the Act and policy directive of the federal government, Exhibit C, of the applicant's counter affidavit to set the 10 years post-professorial experience as one of the requirements for the application. Counsel urged the court to look at the counter affidavit of the applicants vis-a-vis the sections of the laws relied upon by them, and the court would come to the irresistible conclusion that the respondents have performed their statutory duty in advertising vacancy for the aforementioned office of the second respondent, thus could not be restrained by way of an interim injunction sought in this case. Respondent counsel contended that they violated the applicant's purported rights, as the applicants have failed to specifically point out such rights denied, or even argue that the first respondent lacks the power to comply with the policy guidelines of the federal government for the appointment of vice chancellors in the federal universities. He then further relied on the above provisions and the case of Adeleke and others versus Lawal and others on the conditions as outlined in that case, which serve as a guide to the court for the grant or refusal of an injunction. According to counsel, the applicants have failed to satisfy the requirements as outlined by the apex court in the above case, that the applicants had relied on the appointment letters to assume that they have had the unconditional right under the terms and conditions of their employment to contest for appointment into the office of the vice chancellor of the second respondent, but failed to show to this court the particular term or condition of their employment that accorded them the said right to enable the court come to their aid and exercise discretion in their favor. That the respondents have, on the other hand, asserted their statutory powers and the independence of the first respondent to advertise for vacancy in the office of the vice chancellor of the second respondent and conduct interview for the appointment of vice chancellor for the second respondent. It is submitted by respondents' counsel that the applicants, even in their paragraph 4A of their supporting affidavits, admitted to the statutory powers of the first respondent. Counsel then urged the court to construe the admission as one against interest, being the best evidence in favor of the respondent. In support of this point, he cited the case of Mogbo and others versus M/S Uzuko and Sons Trading Company Limited. He then posited that the applicant's unknown rights cannot compete with the legal rights of the respondents on their affidavit and documentary evidence, and there is no quality of explanation that could be offered to convince the court in granting this application against the respondents, who relied on the statutory rights of the first respondent regarding the said advertisement. That it is settled law in Leasing Company Nigeria Limited versus Tiger Industry Limited. I think this is an incomplete citation. I don't have the part there. That, I quote, the claim for an injunction is won and lost on the basis of the existence of competing legal rights. And as such, the court has the power to grant an injunction where the applicant has not established recognizable legal rights, unquote. It is submitted that the applicants have not shown they would suffer more inconvenience than the respondents where this application is refused, as the respondents have shown that leaving the university without the vice chancellor or even the failure to advertise for the said office would cause greater hardship to the staff and students of the university who rely on the directives of the vice chancellor to carry out academic and administrative functions, as well as the payment of salaries for the staff of the university. Counsel relied on E. Akinloshe and others versus AIT Limited and others, amongst other cases cited. It is the further argument of respondents' counsel that as a requirement for the grant of an application of this nature, the applicants in the instant case have failed to provide undertaking as to damages, citing Leasing Company Nigeria Limited versus Tiger Industry Limited, Supra. According to Respondents' Counsel, the first respondent has, in compliance with the provisions of the above provisions of the Act, completed the appointment of the Vice Chancellor for the second respondent, the subject matter in this case, that the successful applicant has been announced on the 12th day of December 2025. Hence, there is nothing left undone to be restrained. In other words, the act sought to be restrained by the applicant has been completed, while an injunction is not granted against a completed act. He cited, amongst others, John Holtz, Nigeria Limited versus Holtz African Workers in Nigeria and Cameroon. To counsel, interim relief sought as in the instant case are granted in a situation of real urgency and meant to last until a named date, until further order, or pending the hearing of a motion notice between the parties. He relied on Ilori versus Benson and others. That the application in the instant case was tagged as motion on notice, but the relief sought are interim in nature, which, if successful, are meant to last until the hearing of motion on notice. Unfortunately, the applicant did not file any other motion or notice seeking an interlocutory injunction. Thus, they are not entitled to the discretion of this court for interim injunction against the respondents in this case. He then urged the court to resolve the sole issue in favor of the respondents. There is a further and better affidavit filed in opposition to the defendant's counter by the claimants. It's of 4 paragraphs and it's dated and filed 19 January 2026, deposed by the second claimant. This court held counsel to the parties on 22nd January 2026 when they both adopted their written addresses on behalf of the parties. In adumbration, respondents' counsel submitted that what the claimant's applicants want to stop has been overtaken by events, to which the applicant's counsel submitted in the contrary. The respondent submissions are based on speculations. Now, decision of the court. I read all the processes filed and exchanged by the parties regarding this application for interlocutory injunction. By their affidavit in support of application, the second applicant is challenging the advertisement done by the defendants for the post of Vice Chancellor for the Federal University Gusau. That's the second respondent. That the post-professorial 10 years experience, which is Exhibit B, set by respondents as a criterion, deviates from the universal adopted tradition by other universities, as the Usman Dan Fodio University, Sokoto, amongst others, that the action taken by respondents have affected the claimant's right to participate in the Vice Chancellor selection process. The case of the respondents, on the other hand, is that they followed the guidelines and criteria in advertisement for the post of the Vice Chancellor of the first respondent, as communicated to the respondent by the Federal Ministry of Education, Exhibit C1 and C2. Thus, that they acted within the scope of their statutory powers. The respondents have in their paragraph 28 of counter affidavit deposed to the fact that the selection process had commenced and ended on 12 December 2025. The applicants have, however, contended that there is no evidence before the court that the selection process was concluded. By definition, an injunction is a court order prohibiting someone from doing some specified act or commanding someone to undo some wrong or injury. In other words, it is an equitable order restraining the person to whom it is directed from doing the thing specified in the order or requiring, in exceptional situations, the performance of a specified act. See Adenuga versus Udumeru, 2001, 2 NWLR, Part 696 at 184. There are guiding principles to the grant or refusal of interlocutory injunctions referred to by both parties in their submissions. Hence, recasting same is unnecessary. Be that as it may, for the applicants herein to succeed in an application of this nature, they must satisfy the conditions as stated in Adeleke versus Lawal, 2014, 3 NWLR, Part 1393, page 1, Supreme Court, and equally Kotoye versus CBN, Supra, to mention a few. The applicants particularly must give an undertaking as to damages, which they have failed to do. Again, I find from the facts as presented by the parties in their respective affidavits that there is no escape route for the court to avoid delving into the substantive matter, where the court attempts to deal with the issues in this application. Hence, in order to avoid falling into that temptation of making any pronouncement which will prejudge the matter in respect of evidence which is to be led, the court shall desist from doing so. See case of Kolito Nigeria Limited versus Dalisu, 2010, 2 Nigerian Weekly Law Reports, part 1178, page 213 and 217 to 272, paragraph G to A. Adeleke versus Lawa Supra. In light of the foregoing, this court is not inclined to granting this application. It is refused and hereby dismissed. The matter shall proceed with definite hearing of substantive matter, and same shall be accorded accelerated hearing. Ruling is hereby entered accordingly.
Haastrup, please.
My Lord, we are very
You're welcome.
grateful
So
for
we'll give you a date.
Yes.
What's about this? Mm. We are looking at, we have dates in February, so we'll suggest the dates. So council, you pick any of those dates.
The court pleases.
Sorry?
As the court
Second week
pleases.
February.
Second week.
We'll look at that.
The how many? 1, 6, 6,
That's from
26.
13th, yeah?
Second week will be 16, 16, 17, 18.
Okay.
We can take
So look
18.
at 16, 17. We
18.
have 18.
Yes.
Yes, we
I
can
think
look
18.
at, let's see, 16th.
No, my Lord, sorry. I think if we can be
About this,
accommodated on the 18, we appreciate
what
it.
about 20th of 20th February?
That's Friday.
Yes.
Yes. Yes, my Lord,
Yes.
for us it's convenient.
So that would be 9 a.m., please.
Nay, my Lord, I'm sorry. I have a request to make. I don't know. We intend to have a physical hearing instead of this virtual hearing via Zoom.
Yes, you are welcome. I would have very much love that. Yes, you can come
Thank you,
down to
my Lord.
Abuja. Yes.
Thank you, my Lord.
So I'll put it on record. That's the oral application by the defendant's counsel. So you come with the witness to Abuja. Yes. So we
Yes,
do
they will
the
come with
next.
their own faith.
Yes, I know, but you are the one asking for that. Yes. So even
Yes,
when it's
I will. I don't have problem with that, my Lord.
okay. The claimant counsel is before me here in Abuja. So let's have the witness in Abuja, witnesses by the next hearing date. Okay, yes. So that's
Yes.
what date? 20th February. Yes.
So they can come with their 3 witnesses. I think that's the
Yes, we
consideration
don't have
for
any
me.
other matter for that day. So I think we'll
As the-
just fix this matter alone for that day.
Thank you. As the court pleases. My Lord, we are very much grateful.
So case is further adjourned to 20th day of February 2026 for definite hearing.
As the
And
court pleases.
this shall be done physically at the Abuja division of this court. The claimant counsel shall prepare all witnesses for trial.
As the court pleases.
So I think that should be all regarding this matter.
The court pleases.
We still have one. We'll take the Adoptions. Do we have any counsel online regarding SKO 6 2024, which is for definite hearing? Abbas, Sokoto
Yes,
registrar.
yes, my lord.
Do we have any party in court or any of the council regarding number 6 or SKO 6?
I'm in
Yes,
court, my lord.
some
I'm
of
in
the
court, my
parties,
lord.
Yes,
some
so
of
we'll stand down the matter again for 10 minutes. We take 2 matters for adoption in for Abuja division here. So we'll get back to you. We'll reconnect in 10 minutes or 15 minutes. Let me give you 15 minutes from now.
Escort, please, my lord.
All right, thank you. So the case is stood down, please.
Escort, please, my lord.
Oh, good.
Abbas, Sokoto. We have passed 10 minutes. Abbas, are you connected?
Yes, my lord. I'm with you, my lord.
Okay. Thank you. Okay, let's have the last matter on the course list.
Third place, my lord. NICN/SK/06/2024 between Sani Suleiman and 29 others versus Kaduna Electricity Distribution Company, PLC, KEDCO. My lord, the case is for definite hearing.
Yes, parties.
Yes, my lord. Some of the claimants are in court. The first claimant,
Yes,
the fourth claimant,
yes,
sixth claimant,
yes.
and the 19th claimant. All are in court.
Okay, all right. All right, they can go back to their positions. Yes. How about defendants?
Daniel Abu, the head of legal department, Kaduna Electric.
Yes,
Amina Mayaki, Employee Welfare and Relations Officer, Kaduna Electric.
Amina who?
Mayaki,
Okay. Your designation, please.
Employee Welfare and Relations Officer.
Any counsel in matter, please.
My lord, the claimant counsel called me. He didn't reach court. He was in his way, my lord. He was from Birnin Kebbi.
Okay.
He said in next 30 to 20 minutes he will be in court.
Yes, you may take your leave, counsel. How about defendants' counsel?
With profound humility, my lord, I'm Valentine Ajibu.
Yes.
Announce my humble
Valentine
appearance.
Ajibo for defendant.
Yes, my lord.
Yes, you had information being passed across by the court registrar.
My lord, it's unfortunate that he's still on the way. I don't know what to say because we got hearing notice for 9 o'clock, and then
Okay.
if he's not still there by now, then I really cannot say whether he will really be there.
Do I allow you to stand down and maybe you try to reach counsel? Or maybe for the court registrar to call him, because since for him to have communicated that information through the court registrar for the attention of the court. So I think we should, in the interest of justice, allow that. It said 30 minutes. So I don't know 30 minutes from when. I wouldn't know. Yes, Abbas, I wouldn't know when that information was sent across. Yes, Abbas?
Yes, my lord.
When did you receive that information?
My lord, 5 minutes ago, my lord, before we log in now.
Okay, 5 minutes ago. So I think,
yes, my lord.
okay, so I think we should give him some 20 more minutes. Yes. Ajibo, are you with me? Ajibo.
Yes, my lord.
Yes. He said 5 minutes before we logged in, so let's give him some 20 more minutes. Stand down.
As God pleases.
Yes. So Abbas, please note it. As soon as it's 20 minutes, you get connected, please.
As God please, my lord.
Yes. So the case
Stand
is still
down.
down for 20 minutes.
As God please, my lord.
All right. Thank you.
AGK.
To sai ka miƙa mu.
Abbas, is he here now? Hello, Abbas, is elected counsel for the claimant there now?
I should log in. So I'm waiting for her to come in now. I
But is
log in.
elected counsel there?
It's okay now. It's okay, sir. Yes, Abbas.
My lord, I'm with you.
Okay, let's get started, please. Yes.
NICN/SK/06/2024 between Sani Suleiman and 29 others versus Kaduna Electricity and Distribution Company PLC. KEDCO. My lord, the case is for definite hearing.
Do we have the same legal representation and parties?
Yes, my lord.
Yes. Do I have the head legal department?
Yes, my lord. Daniel Abu.
Daniel Abu. Yes. Do I have
Daniel.
Meyaki?
Yes, my lord.
Okay, thank you. Then I have here, is it counsel now? Counsel for, I have Ajibo.
Yes, my lord, for the defendant.
Valentine Ajibo for defendant.
Yes, my lord.
So do we have the claimant counsel now present in court?
Yes, my lord.
Okay. Please announce your appearance. Claimant counsel, announce your appearance, please.
May it please my lord.
Yes.
Umar Aminu Kalgo. My lord,
yes.
I humbly appear for the claimants.
Yes, sir, counsel.
My lord, this matter comes up today for definite hearing.
Yes.
My lord, yes. We are ready, my lord.
Yes, where is the witness?
My lord, we have...
Tokwe. Where is the witness? Can't see anything here. It's from their end, eh? If we can't see the witness, I can't proceed. So I need to see the witness. Yes, where is the witness?
My lord?
Yes, please.
My lord, we have documents to tender from the bar.
Do you have any witness, please, to present before the court? Sorry?
We have, my lord.
So where is the witness?
The witness is Sani Musa Kamari.
Where is he? I need to see the witness.
My lord, the witness.
Counsel, if you are not ready, we will take another date for you to put your house in order. If I don't see the witness, I will not proceed, except if you are doing away with the witnesses.
No, my lord. My lord, the witness is standing. It's just that the place is not that very...
You ought to have organized yourself, counsel, with due respect, and your witness as well. Yes.
My lord, I'm sitting in the courtroom here in Sokoto because I know I'm taking witnesses. That's why.
So the witness should have been there as well.
Okay, he is here, my lord. Look behind me, my lord.
I can't see anyone. Abbas, where is the registrar? Let me see the court registrar. Abbas.
Yes, my lord. I'm hearing. Yes, my lord. I'm hearing. Witness box,
Is
my
the
lord.
witness
Witness
there?
box, my lord. Yes, my lord. He's in the witness box. Yes, my lord. He's in the witness.
What's the problem then?
Hello, my lord. Hello, my
Yes,
lord.
just hold on. Maybe you should go and call Aziz. We can't do this. Because I can't see anyone. Go and check the height people that are there. Thank you. It says switch camera. I'm coming. Namiwaki. Yes. This is Abbas now, Sokoto division. Why can't we see him? It's supposed to show all of them. Go with participant. Sokoto now. Why are we not seeing them? Okay. It's supposed to be here, Abi. Abbas, are you with the witness there?
Yes, my lord. The witness is in the witness box, my lord.
Okay, let's go ahead. Yes, counsel. Claimant's counsel.
Respectfully, my lord.
Yes, Abbas.
Yes, my lord.
Yes, proceed. Proceed, yes. And do what you are supposed to do. The witness is there.
Yes. Okay. I want to affirm all affirmation. After me. I said one. I said
Maliki.
you solemnly swear affirm. Yes, I shall give. In this case, is the whole truth, nothing but truth. So help me God. My Lord, not.
I didn't hear you, Abbas. I didn't. Is he affirming, or did he affirm, or he sworn on the Holy Quran?
My Lord, no, it's affirming, my Lord. My Lord, no.
Can we take that again, please? The connection
Okay,
is, I don't know whether it's from your end or my end. Can we
my
take
Lord,
that again?
Your end, my Lord.
Okay, so it's from our end. Yeah? It's clear from there.
I said Musa.
You solemnly affirm
Sorry, affirm.
all the witness
Yes.
I shall give. In this case, it's the whole truth.
The evidence I shall give, not the witness. The evidence I shall give in this case.
Yes.
Yes.
The whole truth.
Yes.
Nothing but.
All right. Okay. No. It's not with the Quran. So you leave that one out. The evidence I shall give shall be the truth, the whole truth, and nothing but the truth. And it ends there. All right. Okay. Yes, claimant counsel.
Yes, ma'am.
Thank you, my lord.
All right.
Kindly tell the honorable your name again.
My name is Sadiq.
Where do you live?
I'm living in Kebbi State.
Do you know in this case?
I know them.
Do you know the defendant in this case?
I know them.
You asked him if he knows, is it the defendant or who?
My Lord, I asked him whether he know the claimants.
Okay.
He answered in the affirmative.
Yes, and the defendant as well.
Yes, my Lord.
Yes.
Did you make any witness statement regarding this matter?
Yes. Yes.
Yes.
If you see that statement, will you be able to recognize them? My Lord.
Yes.
With the kind permission of the court.
Yes, go ahead, counsel.
My Lord, the witness statement on all are at page 18 to 20 to 20
Page 18 and what?
Of the complaint.
18 and which other page?
Page 18 to 20. 18 to 20. Of the complaint. Complaint.
Yes.
And so,
dated, please, can you hold on, counsel? Dated when, please?
Okay, my Lord. Okay, my Lord. My Lord, it is dated 4th day of September.
24th September.
Yes, my Lord. Yes, my Lord. 2-4.
Yes, he has confirmed that as his witness statement or no.
My Lord, I'm trying to give him. I'm identifying them, my Lord.
Yeah, show him.
My Lord, he equally testified on the reply we filed.
Yes.
At page 25.
Can you show the witness, please? That reply.
My Lord, I want to show him the witness statement on oath at one time, my Lord, both.
Okay, go ahead.
So my Lord, the second one is on the reply we filed. It is at page 25.
Yes.
To 33.
It's dated when? 11th June or when?
11th June 2025, my Lord.
Yes.
My Lord, with the kind permission of the court, we present this witness statement on oath to the witness for identification.
Yes, go ahead. Let him look at them and confirm to court if those statements are for him.
Okay.
Yes,
My Lord.
my Lord.
Yes.
This
This is the second one of my.
Yes, that's in reply to the statement of defense. Yes.
Yes, my Lord.
Yes.
My Lord, the witness having identified the witness statement on oath and adopted same. We ask the honor.
Counsel, you are not the one giving evidence. Ask him. I hope he understands what we are doing. Okay. That these statements will stand as his evidence in chief.
You want this witness statement on oath to tell us your
That
testimony in
stands
this.
as his evidence before the court. Let him understand that. Then we have it adopted then as his evidence in chief.
As the court pleases, do you want the court to take this your witness statement on oath as your testimony in this suit?
Yes.
Yes, counsel.
My Lord, the witness adopted the statement on oath.
Yes.
My Lord, that will be all for the witness in evidence in chief.
Is this the only witness for the claimant?
No, my Lord, we have 4 witnesses.
Okay. All right, okay. So that is all in chief regarding this CW1.
Yes, my Lord.
Defendant's counsel, are you ready?
Yes, my lord.
All right, let's go ahead, please. Yes, counsel.
Okay. Sani Musa Dan Maliki.
Yes.
Can you hear me?
I can hear you.
Okay. So is it correct? It is correct that you don't have the authority of other claimants to represent them in this case.
You say?
It is correct that you don't have the authority of the other claimants to represent them in this case.
I don't understand.
You don't understand?
Yes, ma'am.
Okay. No. You know we have more than, you are not the only claimant in this suit. There are other claimants. Okay.
Yes, my lord.
All right. So do you have anything to show that you are standing in for other claimants? That's authority to represent them.
Yes, my lord. But
okay.
I cannot tell you now because it's all right.
I can't hear you, please.
Everything is all right. It is inside our.
So you have the authority to represent the other claimants?
Yes, my lord.
All right. Yes, defendant can say he has the authority.
Is there any document that conveys this authority before the courts?
No.
Yes, counsel said no.
Okay. It is correct that at the time you were employed by the defendants, your employment letter was issued to you personally.
Yes, witness.
You say?
As at the time you were employed by the defendants, Kaduna Electric, it is correct that the letter of employment was issued to you personally.
Yes.
Yes, counsel.
It's also correct that the letter of dismissal, your letter of dismissal from Kaduna Electric, the defendant, was also issued to you personally.
Yes.
Is that? What? Yes, counsel.
It is correct that the letter of employment and that of dismissal of other claimants were not issued to you.
Say?
Other claimants in this case, when they were employed, they gave them letters. And also when they were dismissed, letters were issued to them. Those letters were issued to them and not to you.
Yes, issue them.
What's your response, please, witness?
See whether the was given to us.
Was it issued to you? The letters of employment of the other claimants and their dismissal letters, were they issued to you? Sorry?
It's not issued.
Were they issued to you?
It's not issued to me.
Okay, all right. Yes, sir, counsel.
This is your deposition before this court. It is correct that it was in your lawyer's chambers you signed them.
Yes.
Okay, he said yes. Yes, counsel.
It is correct that you knowingly presented documents or credentials to the defendant as at the time of your employment that contains falsified dates of birth. It is correct that documents, there are documents you presented to the defendant when you were employed that contained wrong dates of birth. Your date of birth there was wrong or were wrong.
No, by the time it's not a wrong.
So he said it is not true.
It is correct that the defendant had a verification exercise involving all her staff.
Yes, sir, witness.
You say?
It is correct that the defendant conducted a verification exercise involving all her staff, including you.
Yes.
Yes.
It is correct that during that verification exercise, it was revealed that the documents you presented had conflicting dates of birth.
Yes.
Yes, sir, counsel.
It is correct that after this conflicting dates were revealed to you, you brought in statutory declaration of age to correct the conflict or to resolve the conflicts.
Yes, witness.
My lord.
Yes.
Please.
That after this verification exercise, that during the verification exercise, it was revealed that you presented, that the documents you presented had conflicting dates of birth, and you answered yes. And it was after that
Yes,
that you now brought in a statutory declaration of age to correct those conflicting dates. Is that true?
It's true, my lord.
All right. Yes, sir, counsel.
It is correct that the defendant was not satisfied with your presentation, but the defendant still gave you another opportunity via memo dated 1st of April 2024.
Yes, witness.
Yes, yes.
Okay. Yes, counsel.
Based on that memo dated 1st April 2024, you made another representation to the defendant in respect of the conflicts about your date of birth.
Say that again.
Following that letter given to you of 1st April, you made another representation to the company, to the defendant, about the conflicts in your date of birth.
Yes.
Yes, sir, counsel.
It is correct that the other claimants in this case, as at the time they went for their verification, the verification exercise, you were not there.
You will not.
You were not part of those that conducted verification for the other claimants.
Yes.
Yes, sir, counsel.
The document they submitted during the verification exercise were not submitted to you.
Will not submitted to me. Yes.
Yes, sir, counsel.
You were also not there at the management disciplinary committee meeting that heard the cases of the other claimants.
No.
Yes. Okay.
Hello?
Yes, go ahead,
Hello?
counsel.
Okay, it is correct that all you have said about the other claimants in this case is based on what you were told by them.
Yes.
Yes, counsel.
My lord, that is all for this witness.
All right, thank you. Any re-examination?
None, my lord.
Okay. All right. So if that is all for this witness who is on record as CW1, then the witness is hereby discharged, and the witness, you can step out of the witness box.
As the court pleases. My lord.
Yes. Yes, please.
My lord, this is the witness that we can take today, my lord. The
Why?
reason
Why
being,
didn't you prepare the other? Yes.
my lord, the reason being that we have documents that we want to tender through the bar.
Okay.
Which would be vital in taking the other witnesses, as well as the cross-examination of the defendant.
No, we will speak for ourselves. You don't know what is important for me, sir.
You can't say for defendants. Just you said you don't have your other witness here because you have to tender some documents
As a
through the next witness, and you are not
Right.
ready with those documents here. If I really got you right.
Rightly guided, my lord.
Okay.
My lord, we will sort out those documents, considering that there are many. With a schedule so that it will be easy for the court to mark them.
Okay. No,
Since it
you
is
will identify those documents, and the markings you put on them is what the court is going to adopt. So you sort them out.
okay,
You
my
sort
lord.
them
Okay,
out. If it's annexure A, B, C, D, or annexure 1, 2, 3, 4, the court will adopt that. I'm not going to sort them out for you.
As
So
the
you
court
sort them
pleases.
out, and you do that alongside. So you send the schedule to counsel on the other side and settle regarding those documents.
The court pleases, my lord.
So would they suggest the available dates to you? Yes, defendants counsel, I hope we are on the same page.
We are, my lord.
Okay. So let's see, what dates do we have for Sokoto for continuation of trial? And if I may ask, claimants counsel, how many more witnesses do you intend to, on record, do we have on record? Yes, claimants counsel, are you with me, please?
Yes, my lord.
How many more witnesses aside this CW1 do you still
My lord,
have on record?
three, my lord.
All right, okay. So let's see, give me a date. No, we don't have, we may not take all of them on the same day. It depends on how the evidence, 20th of what? You have 20th of February. So both counsel should look at your respective diaries, please.
As the court
20th of February is a Friday. It's convenient to.
Yes, the court is sitting on that day. There's a Sokoto matter for that day. I think it's just an application to hear the application. So we can accommodate you. If, yes, please, can you confirm from your diary?
My lord.
Yes.
My lord, Friday is all right, my lord. The 20th is okay.
Yes, Ajibo, I hope both counsel are in agreement.
We are, my lord.
Yes.
Okay. So case is further adjourned to the 20th day of February 2026 for continuation of trial. All right. So that should be all for today.
That's all for Sokoto, my lord.
All right, thank you. So you can now exit the platform. Thank you.
Thank you, my lord. He's looking.